Okay. All right, I figured I would record these and then I would upload it to YouTube so that if anybody wants to go over it, I mean, I know you'll have the questions and all, but this way if somebody wants it for later.
Hi, Gloria.
Hi.
I sent you a message regarding the match quiz ethics. I'm not sure if you
ethics. I haven't had time to take a look at it, so I will look at that.
Okay.
So yes, I did get it.
Okay, thank you.
You're welcome. All right, for the YouTube, will we get the link? Yes, I'll put the link up there. You know, once I get it set up, you'll do it. You'll get the link. Okay. So, because I've had good responses, so I figured, well, might as well do it again. All right, so this is going to be a different one. Okay. If you're new here, let me just go over the housekeeping again. If you're new here, we are in review. You're more than welcome to stay. However, it will be in your best interest to come back on Monday because that's when the new class starts. Okay. And if you are going to stay, please put your name into the chat. Okay. So that's where we are. How's everybody doing? Are we alive?
Alive.
Okay, good.
Feeling good.
All right, good. Okay. So this was the midterm that I gave you a while back. I don't know how many of you took it, how many of you didn't take it. All right. And so I figured we would go through this to start. Now, this would have been a good barometer to tell you where you are regarding all the chapters that we had done up until then. Okay. So it would have been chapters 1 through 12. So let's get started. Can you see my screen? Okay, good.
Yes, we can see it.
Yeah.
Good. And so just if anybody's going to talk, all right, can you send you the link for Jorge for what? For the test? Is this your first test or your second test? If that's what you're asking. First, okay, no worries. Oh, actually, then I should be able to do it right now. Hold on. Paste. All right, there you go, Jorge. Good luck to you. All right, and then let me know how you did. And good luck to you too, George. All right, so. Excuse me? Okay, so if you don't want to talk, which is fine, okay, then in that case, I need you to put the letter into the chat. If you want to talk, the only thing that I am going to ask, because I can't tell the differences, I guess I'm getting hard of hearing, it's going to be apple, boy, cat, and dog. All right, just so that there's no misunderstanding. All right, and are we all ready to get going? Okay, here we go again. All right, 3 yeses, I'll accept that. All right, so a broker incorporates his business and subsequently dies, and another person becomes the broker for the corporation. Okay, what's going to happen? Any listings he has immediately terminated. All listings may be canceled by the principals without further clause. New listings must be secured from the owners of all properties being handled by the office, and contracts with principals do not terminate upon death of the broker under these circumstances.
D as in dog?
Dog is correct. Ding, 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 ding. And do we know why?
Someone else in the agency with, I think, what is it, 3 or 2 years experience can take over within 30 days?
No, that's not the reason.
Nah.
Because the contract is with the
broker's office, not with a person.
Well, that's a good answer. Ding, 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 ding. And the answer is because it's a corporation. Okay. So anybody in the corporation, if they are a broker, they can take over. And you are correct, Waleed, that the listing is with the corporation, not with the individual. All right. But again, just to make sure you all understand, it's the corporation. That's the key word that is giving you is where you're looking at. Okay, so we're going to do number 7. I'm going to go back and forth a little bit. So number 7, the rights of possession, control, disposition, and enjoyment which accompany ownership are called what? I'm not going to read every word unless you want me to.
Bundle of rights.
Ding, 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 ding. And we got that. Pretty much everybody got that. Okay, number 8, the boundary of your property line can be changed by what?
A, apple, accretion.
Accretion.
No, I took a bite of the.
All right, so we got A, we got B, we got C. Okay, so apple, boy, cat. Okay. No D. No, we don't have a D. Okay, so apple, boy, or cat. So B, let me just ask you this. Does that have anything to do with land amortization?
No.
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 So now acceleration, does that have anything to do with land?
No.
I don't think so, no.
Good. All right. So then the choice is between A and C. Okay. So accretion is adding on of land and C is losing land. Okay. And so the answer is correct. Whoever said A, it's accretion. We're adding land. Ding, ding. Okay. A is the correct answer. All right, we're going down to number 9. When the title is gained because a portion of a water course permanently dries up, exposing land, it is called what?
B, erosion.
No.
Okay.
Exposing
D.
land. Exposing land is the key word.
A.
Hey, ding, ding, ding. Reliction is the correct answer, right? Remember when I told you when a lake permanently dries up, that's reliction. All right, that was my version of remembering it. Okay, so A, reliction is the correct answer. Okay, we're going to go now over to number 2. So a real estate broker typically can do what? Prepare an abstract of title, prepare a deed, prepare purchase and sale agreement, or none of the above.
Cat, C.
Cat, ding, ding, ding. I heard the little girl say cat. Bravo. Okay, next, number 3. Which of the following requires licensees to provide owners with a copy of the Attorney General Memorandum on the Law Against Discrimination?
Okay, which one requires?
D.
Nope.
No. Okay, then A.
Nope.
I'm lost.
NJ Rec.
NJ Regs. Yep. B as boy. The rules and regulations of the New Jersey Real Estate Commission is the correct answer. Okay. Because the law against discrimination, that's the law, but that's not why we have to give the people a copy of it. It's the rules and regulations of the Real Estate Commission that forces us to do that. Okay, number 4. With regard to maintenance of trust accounts, which of the following statements is not true? And I'll bring it up a bit, hopefully, so you can see it. It's higher up.
Okay, which is not true. Okay.
Yep, that is the key word.
Yeah.
D.
Dog is correct. Okay, so dog is the depository institution may be located in another state. If it is an approved depository in the other state, that is not true.
Okay.
Okay? Any account that a broker has must be within New Jersey. All right, number 5. Now this is old, I will tell you now, so the numbers might be different in our book, okay? But we can still figure it out. So the maximum fine for violations of the Real Estate Sales Full Disclosure Act is what? And I will see if I can find it in the book to see if I have to correct it or not. Oh, wrong book.
I thought it was 10,000, but I could be probably wrong. So, and I don't see that here.
It's a much higher number.
It's 50,000?
Yep, ding, 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 ding. All right, that is the correct answer.
Maximum, okay.
Okay, so it's this Real Estate Sales Full Disclosure Act is what we are talking about. Okay, all right, number 6. Which of the following is not an appurtenance?
Trade fixture?
Ding, 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 ding.
Trade fixture.
Ding, 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 ding. That is the correct answer. All right, very good. All right, so we are now on number 10. An owner of a life estate can do all but one of the following.
An owner of a life estate do all.
Your room light. Oops.
Is it C?
Okay, that is the correct answer. Devise her interest. And what does devise the interest mean?
Is it she cannot like divide her estate into for different people?
No, that's what is V?
Or give it away?
Okay, or what is V? Half of what? Remember, I keep on telling you a V is half of what letter?
Oh, will.
Ding, 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 ding,
Can't
ding.
will it to anybody else.
There's your answer. Ding, 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 ding.
B.
C is the correct answer.
I just want
Number 11. Hold on a second, I gotta mute people. All right, so if Jones holds a fee simple estate in property, which of the following acts will result in his being left with a less than freehold estate?
None of the above.
Okay, good. I got 2 D's, dogs, and that is correct. None of the above. So what is less than freehold estate? What does that mean? Leasing, ding, 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 ding. Very good. All right. So in this case, none of these are making this person own a leasing, have a leasing property. They still own the property, even though they've allowed these other, it is leasehold if they decide to lease the land, but they still own it. So they don't, it's not a leasehold estate. A leasehold estate is a tenant that's leasing the property from the owner. Okay. All right, number 12. So far, so good, you guys. You're shocking me here. All right, so number 12. A conveys property to B, and C, who is unrelated and not joint tenants, So if B dies, what happens?
C is the sole owner.
Nope.
Damn.
Is it B as in boy?
Boy is correct. Ding, 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 ding. The B's share goes to his heirs. Key word is they're unrelated and they are not joint tenants.
I missed the not part.
Uh-huh. Okay.
Big.
See, there you go. Okay, 13. Okay, yeah, there you go. All right, so a corporation cannot hold title to real property in New Jersey with another as a joint tenant because why? All right, I got 2 B's, 2 boys. That is correct because of its perpetual existence. Okay, number 14. In New Jersey, condominiums are regulated by whom? By who? Okay, Caitlin, good. Anybody else? Oh, Selena, nope. And she asked Brandon, yes. So the answer is D, dog, and it's the Horizontal Property Act. Okay, that's who regulates condominiums. All right, we're going to go 15. Which of the following is not true? All right, and the apples have it. So the answer is an inter vivos trust, not rust, is created by a beneficiary. That is not true. Okay, who creates the trust? Well, that was my question. There's no A or B. Who creates, sorry about that. It's my question. So who creates the trust?
Is it the will? Is it by a will?
No. The trustor or the owner or the grantor. Ding, 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 ding. Those are all the correct answers. This was not on here. Okay, now we're going to number 16. Okay, so 16 it is. Which of the following would not be a party to a will? Ding, 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 ding. The administrator is correct. Boy is the correct answer. All of you got it. Good. Ding, 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 ding. Okay. The word escheat refers to what?
Oh, I know this one.
Ooh, look at that. And the dogs have it. Woof, woof. The answer is the right of the state to acquire title where the owner dies without a will. Good job, everybody. Good job. All right. Number 18. Which of the following statements are true?
There must be.
Okay, I got the answer. Dog, woof, woof again. A holographic will is valid in New Jersey. Ding, ding, ding. Holographic will, what is that? My question. Holographic will, what is
A handwritten will?
ding, 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 ding. Okay. All right, number 19. Handwritten is the correct answer. Yep. So 19, when an easement appurtenant exists between two parcels of land which are separately owned. Ooh.
When it easement.
So when an easement appurtenant exists between two parcels of land and they are separately owned, all right, so I got a combination of answers. So the correct answer is the dominant tenement is benefited by the easement. So C, cat, is the correct answer. So when an easement appurtenant exists between two parcels of land which are separately owned, the dominant tenement is benefited by the easement. Okay, now my question, who can terminate the easement? Okay, dominant is the correct answer. Thank you. Dominant is the correct answer. The dominant tenement, when they no longer have a need for that easement, they are the ones that are going to be terminating, obviously everything in writing, terminating the easement. Okay, number 20.
So I'm sorry, what was the I missed the letter.
C,
okay, thank you, sorry.
welcome. No worries. Okay, a gift of land for some public use made by the owner and accepted for such use by or on behalf of the public as streets in a plotted subdivision is called what? Okay, good answers.
B.
Yep, ding, 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 ding. B, dedication is the correct answer. Okay. All right, 21. The right of a water company to lay and maintain water mains along the rear of a lot is called or known as what? All right, I'm getting the correct answers. Cat is the correct answer. Easement in gross. Ding, 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 ding. All right, so now we're going to 22. So 22, generally the title insurance coverage extends to hidden and unknown matters. Okay, and I'm getting good answers here as well. A is the correct answer, whether or not they are of record. Ding, 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 ding. Okay, 23. Which of the following is not an objective of a title search?
A.
Ding, 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 ding. Everybody's got it. A, it's established relative value. That's not the reason why we're doing a title search. What is the reason that we're doing a title search? My question.
To make sure there's no liens on the property.
Okay. Would we say free and clear?
Free and clear.
Okay, good. All right. So number 24, Mr. X, a bona fide purchaser for value who records his deed, would take precedence over a grantee with a prior unrecorded deed.
Hey, this goes to him, which takes precedence.
All right, I got 3 answers, 4, 5. Okay, so I will accept it. The answer is cat, ding, 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 where Mr. X had no knowledge of the previous transaction and the prior key here, the prior grantee did not take possession. Remember our little example that we had? And somebody took possession of the property, right? So that person would have priority over the person that recorded it. But in this example, nobody recorded it except for Mr. X. And so therefore he is going to take precedence over an unrecorded deed. Okay, 25. If A sells a property to B and B takes possession but does not record his deed, and then subsequently A sells the property to C and C records his deed, who owns the property?
B, bat.
Yeah, ding, 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 ding. Okay, so B is the one that has it because they took possession. All right, we just stated that. Okay, number 26. Any person, partnership, association, or corporation who authorizes or employs another called the agent to perform certain act on his behalf is what? Ooh, great answers. All right, ding, ding, ding. Cat is the correct answer, and they are the principal. Okay, so they are the principal. Okay, number 27. Which of the following persons would not have fiduciary duties to a principal? Okay, great job, everybody. Ding, 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 ding. C, employees do not have fiduciary duties to principals. Number 28, known hidden defects in a property must be disclosed by whom?
D is in
D,
dog.
by everyone.
Everybody. All right. Okay, 29. A person who is given authority to perform a specific legal duty by another is what?
Power of attorney, A?
Nope.
Oh.
So I had some of that answer too. So the correct answer is boy, attorney in fact. Power of attorney is the document.
Oh, okay. Got it.
Okay. Power
Tricky.
of attorney is the document. Okay. A typical, I'm not reading these properly. Okay. Well, you better be reading them. There's the answer.
I had to out myself.
You're not alone. You're not alone.
Okay. In a typical, I mean, if you want me to stop and give everybody a minute to answer, I could certainly do that. Then this way it'll give you, or half of 30 seconds. But I mean, how can I help it make it better for you?
I personally just need to slow down and read it, just make sure I know exactly what the question is. But if we could slow down just a little bit, because I don't feel like I'm getting through all of the answers before you guys are like throwing out the answer.
Okay, so let me ask you this. Would it be easier if I read the answers? I mean, not the answers, if I read the choices?
Sure. Thank you.
And then that'll slow it down. Okay. All right, so that's how we'll do it. Okay, so in a but I'm not going to do letters. I'm just going to read the choices. So in a typical real estate listing contract, the broker would be best described as what? A general agent, a special agent, the principal for the agent, the principal for the sub-agent. All right, ding, 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 ding. The boys have it, and a special agent is the correct answer. Ding, 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 ding. Okay. 31. A declaration made by a person to an official that he freely and voluntarily executed a deed is called what? An acknowledgement, an authorization, an authentication, an execution. All right, I have a combination of answers here.
Authentication.
Nope.
Acknowledgement.
Ding, 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 ding. That is the correct answer. Acknowledgement. Okay. So when they freely and voluntarily executed a deed, it's called an acknowledgement. Okay. Number 32. A customer may best be described as always the buyer, someone you work with, someone you work for, or the person to whom a fiduciary duty is owed.
The buyer.
Someone you work with?
Ding, 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 ding. That is the correct answer. Someone you work with. Okay. Which type of listing, what's this here? Which type of listing finds the broker the greatest protection, gives the broker the greatest protection? An open listing, a net listing, an exclusive right to sell listing, or an exclusive agency listing? Oh, look at you guys. When it comes to money, you got the answer. Ding, 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 ding. The cats have it, an exclusive right to sell listing. All right, so no matter who brings the buyer, then in that case, they will get paid. Okay. Number 34. Upon completion of a sale, the selling broker was paid $6,000. The portion paid to the salesperson responsible for the sale would be always 50%, established by the Board of Realtors, determined by the employment agreement between the broker and the salesperson, or specified in the sales contract. All right, here we are again with the dollars. Ding, 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 ding. The cats have it. It's determined by the employment agreement between the broker and the salesperson. And that would also be known as, what is the word for that? My question. Well, it is a commission, but what is the determination? The portion is called what? Your portion is called what? All right, what is the division between, well, we're going around and around, so the answer is a split. What is your split with your broker?
I wanted to say that, it just seemed too simple.
That's right. That's always the case. See, you doubted yourselves. Didn't I tell you, start spitting out the answers, because your brain has it, and there's your answer. Okay, 35. An owner who wants to employ more than one broker should give each broker a multiple listing, an exclusive agency, an open listing, or a net listing. Okay, good job. Cats have it again, meow. It's an open listing. Ding, 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 ding. Okay, 36. Broker Smith has a listing on a house which contains a provision that the house is to be sold in as-is condition. Smith learns of a major hidden defect in the property, and when showing a prospective purchaser should do what? Advise the buyer of the defect, point out that the house will be sold in as-is condition, mention the defect to the buyer only if asked, or inform the buyer that the seller has told him of no defect. Apple is correct. Ding, 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 ding. Always advise the buyer of the defect. All right. So we always have to disclose, 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 disclose. Number 37. An owner wishes to list her property but does not want to pay a commission if she finds the buyer herself. So she should negotiate which kind of a listing. An open listing, an exclusive agency listing, neither A or B, either A or B. Dog has it again. Ding, 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 ding. Either A or B is the correct answer. Okay, number 38. Which of the following is not a necessary element in the formation of a contract? Offer, consideration, acceptance, or performance?
D.
Dog has it. Ding, 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 ding. Performance is the correct answer. Okay, number 39. Which of the following parties are not competent to enter into a contract? Minors, mental defectives, drunks, or all of the above?
D for drunks.
And the drunks have it. Oh. All right, all of the above is the correct answer. Oh, sorry. All right, number 40. The transfer of rights under a contract without the release from obligation by the assignor is known as what? Novation, supersedence, assignment, or succession. So the transfer of rights under a contract without the release from obligation by the assigner. All right, so I have a combination of answers here, and the correct answer is cat. Assignment is the answer. If we're assigning it, we still have an obligation to that contract. Okay, novation is new contract, new people, novation. So we have the landlord, let's use that as an example. We have the landlord. We now have a new person contracted with the landlord. So that's the old person. The new person, we have a new contract with the old landlord. Therefore, it's novation. And the original person is out and has no obligation. Okay, number 41. An optionee, by reason of the option contract, has the right to collect rents during the option period, can legally enforce the exercise of the option if the optionor changes his mind about selling, can occupy the property during the option period, or cannot legally enforce the exercise of the option if the optionor objects. All right, so I have a combination of answers. So let me ask you this. Which of the answers, A, B, C, or D, absolutely does not apply?
What is the number of the question, please?
Number 41. Okay, so D does not apply to the question. Okay. What's the other answer in 41 that also does not apply?
C.
B. Okay. By the way, that is the correct answer.
D.
Right? So in option E, by reason of the option, can legally enforce the exercise of the option if the optionor changes the mind about selling. All right, it's remember we said that an option is if I will do this if you will do that. Okay, that's an option. I will do this if you will do that. So it's one-sided. So we're forcing the other person to do it. All right, so in this case, the answer is an option E. An option E, by reason of the option contract, can legally enforce the exercise of the option if the optionor changes his mind about selling. All right, so 41 is boy. Okay, 42. Oh, my question. An option, can we as licensees write options? No is the correct answer. Ding, 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 ding. Okay, number 42. A rescission of a contract is a ratification, a return to the status quo, an amendment to the terms of a contract, an escrow arrangement.
B.
Boy is correct. Ding, 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 ding. A return to the status quo. Okay, so it's like it never existed. Number 43, a remedy in court which would compel a party to a valid contract to sign a deed is known as specific performance, foreclosure, execution, or equity of redemption.
Apple.
Apple is the correct answer. Ding, 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 ding. Right, specific performance. We're forcing that person to sign the deed in this case.
Sorry, we're unable to process your call. Please try again later.
No problem. Try it again. All right, number 44. Acceptance is accomplished when the salesperson signs the contract, the offeree signs the contract, the offeror signs the contract, or the broker signs the contract.
Boy.
Boy, that is correct. The offer.
Subscriber you have dialed is not in service.
Oh, good Lord.
If you feel you
Selena, it sounds like you might have to try that again later.
Yeah, really? Okay, I think maybe that person is trying to get back on here and they can't. That's probably what it is. All right, so let's continue on, 45. So when a seller fails to mention the existence of a mortgage on a piece of real estate, but there is a mortgage, the seller can compel the buyer to complete the transaction if the seller allows a deduction from the sales price equal to the amount of the mortgage. The signing of the contract automatically makes the mortgage void. The buyer has the right to demand a title free and clear of mortgage, or buyer must take title subject to the mortgage.
Apple.
Nope. Good job, Brandon. You're the only one that got it. Oh, Katana, good. Jennifer, excellent. The answer is C. The buyer has the right to demand a title free and clear of mortgage.
Could you explain it?
Can I explain that?
If not, I'll take it as it is and just remember the answer. But
when a seller is selling the property, okay, and it was not in the contract, okay, the seller, they're saying that the seller fails to mention the existence of a mortgage on the real estate. Okay?
I understand. Okay, got it. Just clicked. Thank you.
Okay. All right, so they did not state that there was a mortgage, but the reality that is there is a mortgage. And when, just let me finish forward, when we get a listing with a seller, all right, the listing states that the seller is saying that if there is a mortgage, that when the sale goes through, the mortgage will be cleared and the buyer is going to get a free and marketable title, right? So a quality title is going to be transferred at the close of the sale. And that is what they're signing on the in the listing agreement. Okay. All right, number 46. Assume, not a good word, assume that a contract to purchase for all cash is signed by the unmarried seller and by Mrs. Smith only as the buyer. The method of ownership will be tenants by the entirety. The contract is enforceable, void, voidable, or unenforceable. Ah, Selena, you're back. Your phone is no longer ringing. Ding, 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 ding. That is the correct answer. All right, A is enforceable. The contract is enforceable. All right. So we had some good answers there. All right, number 47. Amos and Bernie have entered into a contract for the sale of Amos's house. Therefore, Bernie has legal title. Bernie now has equitable title. Bernie has no interest until closing, and Bernie has legal title, and Amos has equitable title. B is the correct answer. Bernie now has equitable title. Okay. Number 48. In a deed, the grantee must be of legal age, must sign the deed, must be of sound mind and memory, or must be named.
In a deed, a grantee must be with
D.
Dog is correct. They must be named, but they can be sick, right? Not of sound mind, and they don't have to be of legal age. All right, the grantee, that's the one that's receiving the land or the property. Okay. A quitclaim deed might be used to remove a cloud on the title, to remove an escrow, to terminate a lease, or to evict a tenant. A is correct. The apples have it, and it's remove a cloud on the title. Ding, 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 ding. Number 50. All right. How many questions? Oh, we're almost there. So we got 20 more questions. All right, number 50. The covenant against encumbrances in a deed of conveyance warrants against the existence of all of the following undisclosed matters except mortgages against the land, judgment liens against the land, easements that adversely affect the land, and zoning ordinances that limit the use of the land.
C.
Cat is incorrect.
B. Boy.
Incorrect. All right, I have good answers here. Dog is the correct answer. Zoning ordinances that limit the use of the land. Zoning ordinances is put on by whom? The zoning boards. All right. So it has nothing to do, it's police power. All right. So zoning ordinances would not be a part of that. Okay, number 51. The type of deed that warrants only that the grantor did not impair the title during his or her ownership, except as stated in the deed. So is that a warranty deed, a special warranty deed, a bargain and sale deed, or a quit claim deed?
D.
Boy.
Ding, ding, ding. Boy is correct. A special warranty deed. So that means that I am only going to take care of anything that happened during my lifetime on that property. Okay. Number 52. In New Jersey, a valid general warranty deed need not contain a recital of consideration, a written statement of the warranties, an execution by the grantee, or a granting clause.
A. Apple.
Nope. I do have an apple. That's not correct. I also have a dog. That is not correct.
No one's saying B. Boy.
No, it's number, it's number cat. It's number cat and execution by the grantee. Yeah, you're correct. B or C are the two choices. Okay. And the answer is an execution by the grantee. And in this example, what would execution be? Not death, but what would execution be?
Signing.
Signing. Ding, 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 ding. Okay. So it does not need to be signed by the grantee. All right. Okay. To establish, whoops, sorry about that. To establish a claim of title of a parcel of realty by adverse possession, a claimant must hold the parcel for the required time, and such possession must be either exclusive or in common with others, provided substantial enclosure and improvement or annual cultivation can be proven, or uninterrupted for the statutory period with or without the owner's consent, or under any circumstances provided a claim for color of title is filed, or exclusive, continuous, uninterrupted, visible, and notorious.
Boy.
Nope.
Or D. The dog.
Dog
D?
is the correct answer.
Dog is 7. Yeah, I was split on that one.
Yeah. Okay. So again, continuous, hostile, uninterrupted, open, visible, notorious, any one of those words. Okay. All right. Number 54. Joe, Helen, and Mary own a large home on a 10-acre parcel of land, all of which is needed by the state due to the creation of a new highway, state highway. Regarding this case, all of the following statements are correct, except, so the Travers may voluntarily agree to sell the land to the state. The Travers, if the state needs the land for a public purpose, it may obtain title to it, even if the Travers refuse. If the state acquires the land, the owner must be justly compensated for it, or severance damages may be awarded.
Yeah.
A, apple.
Nope.
D.
Gotta be D.
D is severance damages may be awarded, but I want to read the question again. Joe, Helen, and
It
Mary.
looks like B to me.
No, B is incorrect. Let's just get to that point. B is incorrect.
So accept is the key word here. Okay.
Accept is the key word, right? So let's go back to read the sentence. Joe, Helen, and Mary own a large home on a 10-acre parcel of land, all of which is needed by the state to the creation of the highway. Regarding this case, all of the following statements are correct, except. So which one is the not correct answer? That's the question.
It looks like B to me.
No,
C? Is it C?
it's dog.
It is. Oh, yeah.
Dog. Severance damages may be awarded. That's not correct.
Oh, okay. I had said D. I don't know if you said that was.
Chris, sorry, because I
Okay.
was trying to read it out and trying to figure it out. All right. So so again, reading the question is they're saying all of these statements are correct except for, and the answer in this case is D is not correct. All right. They weren't asking us what is eminent domain. They were asking us which one of these is incorrect. All right. So again, that's the wording. All right. Number 55. The act or process of taking private property for a public purpose is called eminent domain, police power, escheat, or condemnation. The act or process.
A, apple.
D, dog.
Dog. The process is dog. Okay. And there's another word for it, but it's through condemnation that they're able to do eminent domain. All right, so the process is condemnation and the action is eminent domain. All right, number 56. In a purchase money mortgage, the seller takes back a mortgage as part of the purchase price. The seller is disposing of a mortgage loan. The buyer is denied prepayment privilege. The seller is denied prepayment privilege. All right, the apples have it. The seller takes back a mortgage as part of the purchase price. All right, number 57. A clause in a mortgage which permits the lender to call the entire balance due if the property is sold or otherwise conveyed by the mortgagor is called what? A defeasance clause, alienation clause, habendum clause, or subrogation clause. And the boys have it. It is the alienation clause, also known as
Due on sale.
ding, 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 ding. You trusted yourself, Jennifer. All right.
Finally.
Good job. Okay. You trusted yourselves. All right. 58. Where a seller is relieved of all obligations under a mortgage, which the buyer is assuming, this would be described as which of the following? Subordination, novation, acceleration, or subrogation?
Boy?
Boy is correct. Ding, 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 ding. Novation.
Yeah, we covered this earlier.
We just talked about that a few minutes earlier. Exactly. So novation is the correct answer. The acceleration clause in a promissory note provides what? Payments must be made more frequently at a future specified date. Payments may not be made more frequently than specified. Upon the happening of a certain event, the entire amount of the unpaid balance becomes due, or none of the above. Okay, the cats have it. All right, upon the happening of a certain event, the entire balance is due. Okay, number 60, a promissory note that provides for payment of interest only during the term of the note would be known as an installment note, a straight note, an amortized note, or a non-negotiable note. Okay, and the boys have it again. It's a straight note or a term note. It's interest only. Number 61, the penalty for complete prepayment of an FHA insured loan during the first 10 years is 2% of the face value of the note at the time of payment, 90 days interest on the remaining balance, 1% of the original loan amount, or nothing.
B, nothing.
Ding, 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 ding. D is nothing. Okay. All right. 62. When you use real property as security for a loan, you either demise it, hypothecate it, assign it, or devise it.
D, devise it.
Okay, okay, so I got 3 good answers. I'll take it. B, boy, hypothecate it. When you use real property as a security for a loan, you hypothecate it. Devise, Chris, means what? It's the V is half of a W.
You're splitting it.
V is half of a W. W is a will.
Right, you're splitting it to your and whoever.
Okay, devising is you are giving it in a will to somebody. All right, hypothecate is the action of getting a mortgage. Okay, all right, 63. The agency of the Department of HUD that buys and sells low-income mortgages is FDIC, Ginnie Mae, Federal Home Savings and Loan, or Mutual Mortgage Insurance Corp. Now that's a tricky one. B is the correct answer, Ginnie Mae. Ginnie Mae only buys low-income mortgages on the secondary market. Ding, 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 ding. Okay, 64. Under a sale leaseback, the occupant of the property would be which of the following? The buyer, the seller, the grantee, or the mortgagee? Okay, B is the correct answer. Ding, ding, ding. Seller is the correct answer. Ding, ding, ding. Leaseback, sale, leaseback. All right. Number 65. Which of the following statements is most correct concerning liens and encumbrances? The owner cannot encumber his property. Encumbrances lower the value of the property. An easement is both a lien and an encumbrance. A mortgage is an encumbrance, but not a lien.
B, boy.
Boy, ding, 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 ding. That is correct. Encumbrances lower the value of the property. Okay. Number 66. In New Jersey, the redemption period for a property owner after a tax sale is 10 days, 2 years, 6 years, or 20 years. And the boys have it. It's 2 years. Ding, 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 ding. Okay, when the court issues an order to sell property to satisfy a judgment, it is known as what? An easement, an encumbrance, an attachment, or a writ of execution.
Dog.
D is the correct answer. It's a writ of execution. Ding, 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 ding. Okay. Which of the following is an encumbrance but not a lien? A mortgage, a restriction, a trust deed, or a tax?
Mortgage. A. Apple. No.
That's a guess. That's not an answer. And the answer is B, boy, ding, 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 a restriction. A restriction is an encumbrance, but it's not a lien. A lien is what? Is it financial or is it not financial?
Financial.
Ding, 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 ding. That is the answer. Okay, number 69. Under truth in lending, the borrower, except in cases of a first purchase money mortgage to acquire or construct a home, has the right of rescission upon notice for how many days? 2 calendar days, 24 hours, 3 business days, or 72 hours? And we got the correct answer. Cat is the correct answer. 3 business days. All right. Regulation Z, okay, prohibits the advertising of credit terms, advertising in general terms such as reasonable monthly payments, both A and B, or neither A nor B. All right, so the correct answer, ding, 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 is neither A nor B.
Oh.
All right. The Regulation Z prohibits advertising of credit terms unless you detail it out, and we are not allowed to say reasonable monthly payments. Okay, so it does not allow A and does not allow B. Neither A or B. Okay, 71. Under the provision of RESPA, which is the Real Estate Settlement Procedures Act, the main thrust is to eliminate any kickbacks that might occur through referrals by closing agents, attorneys for particular title companies, or buyers may not be compelled by the seller to use a particular title company, or both A and B, or neither A nor B. Both is the correct answer. So C is the correct answer. RESPA is there to eliminate kickbacks, and there also to prohibit people forcing buyers to use a particular title company. Number 72, the Equal Credit Opportunity Act makes it illegal for a lender to refuse to grant a loan on the basis of a substandard FICO score, or a poor credit history, or income derived from public assistance, or the applicant's age, minority status.
Dog.
Wrong.
C then.
So the answer is cat. CAT, income derived from public assistance. Ding, 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 ding. All right, they cannot refuse to give a loan because a person is getting public assistance. And the last one, I think this is 73. The American with Disabilities Act covers all of the following except, okay, all of the following except housing discrimination, employment discrimination, businesses that are public accommodations, or individuals with mental, physical disabilities, including AIDS and alcoholism. All right, I see 2 good answers. Okay, so I have 4 good answers. So the answer is number 73 is A. The American Disabilities Act covers all of the following except housing discrimination. What law covers housing discrimination? That's my question. What law covers housing discrimination? Fair Housing Act of 1968. Ding, 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 ding. Okay. LAD covers everything, right? LAD does housing and commercial. So that's not the correct answer. All right. Remember when I was reading to you the Fair Housing Act of 1968? It's strictly residential. All right. So I want to say, well, actually, I'll ask you, how do you guys feel about how you did? Decent. All right. Well, that's chapters 1. That's chapters 1 through, okay, 70-ish. Sounds good. All right.
It felt like I even knew it, or I just absolutely didn't. I think if I would have slowed down.
That would be a good idea.
Yeah.
All right. Okay. Oh, there it is. All righty. Okay, so we'll start with our next exam. See how we do there. Okay. We're going to skip the math questions, just so you know, except I'm just going to ask 1 or 2 items. Okay. So here we are. We're starting in, what was the word for last night? Formula. I think that's what it was. It was formula. Okay, everybody good? We're ready to start?
Yeah.
Yes.
All righty, so here we go. Let's see, just making sure that, all right, he's still not here. Okay. All righty, so a couple executes a sales contract on their home after several counter offers with the buyer. So in this case, the seller is what? The mortgagee, the grantor, the grantee, or the mortgagor?
The grantor.
Ding, 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 ding. Very good. All right, so let me just ask you, what is the square footage in an acre?
43560.
3560.
Ding, 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 ding. Very good. All right, we're skipping the math. All right, we're skipping the math. We had enough of that. All right, so here we go. A seller provides written permission allowing the listing broker, who has a fiduciary obligation to the seller, to work with the buyer. This relationship known as dual agency, sub-agency, special agency, or implied agency. And I'm seeing all the correct answers. Ding, 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 ding. A is dual agency. Okay. All right. A valid contract is a verbal agreement, a 10-month lease, both A and B, B only, neither A nor B, or A only. That's a good one.
I would think it's C for cat, but I'm not sure.
All right, C for cat or.
Yeah.
Oh, wait, no,
I mean,
sorry. Like both were. Wait, it looks funny to me for some reason on my screen.
Your choices, okay, so the choices for the answers are both A and B, okay? Is B only,
Okay.
neither A nor B, or A only. And these are the two items that they're referring to. It's either a verbal agreement or a 10-month lease. So a valid contract, is it a verbal agreement and a 10-month lease? Or a valid contract is
B only. It has to be written to be a contract because verbal.
Oh, wait a second. It's not saying anything here. Doesn't say if it's a licensee or the public. It's just saying a valid contract.
In that case, then it's both A and B.
Ding, 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 ding. That is the correct answer. All right. A contract is defined as an agreement between two or more people, and it could either be written or verbal. The only reason it's written is for a licensee. All right. But it's talking about a contract here. So that's the law of contract. It can be a verbal agreement and it can be a 10-month lease. All right. Everybody okay with that one? All right. Which best describes an example of emblements? Okay, hold on. Okay, so which best describes emblements? Cherry tree, apple tree, tomato plants, cherry tree, apple tree, peach tree, tomato, lettuce, and onion, or none of these? All right, we all agree it is tomato, lettuce, and onion. Ding, 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 ding. Okay, 12. 9 states recognize this system of property ownership where the husband and wife have equal interest in property acquired through marriage. This is known as common law, community property, commingling, or common title. All right, so dog is incorrect. All right, so it's a choice, but obviously C is not correct. We're not commingling an escrow account. All right, so it's either common law or community property.
No, it's common law, maybe.
No, the
Apple.
okay, the actuality is B-boy community property. All right, so each spouse has equal interest in property acquired during marriage, and that would be community property. Okay. All right, number 13. A dad who owns his house free and clear decides to take out a HELOC and let his son make payments. He also signs a quitclaim deed to transfer the home into his son's name. What clause might the lender enforce? Okay, coinsurance clause, acceleration clause, due on sale clause, or cancellation clause? Ooh, Edwin, excellent. Tyler, Anish, good answers. Due on sale clause, because if we're transferring the home into the son's name, it's transfer of ownership, therefore it could be a sale. Okay, number 14. New Jersey Real Estate Sales Full Disclosure Act requires all but which of the following to register with the New Jersey Real Estate Commission Bureau of Subdivided Land Sales when making an offer in New Jersey? Timeshares located in New Jersey, out-of-state residential subdivisions, condominiums in New Jersey, or out-of-state properties subject to an owners association.
Can you see the question again, please? Just a long question.
Yep, hold on. The New Jersey Real Estate Sales Full Disclosure Act requires all but which of the following to register with the New Jersey Real Estate Bureau of Subdivided Land Sales when making an offering in New Jersey? Okay, so I'm seeing a lot of C's, and the one of the keywords here is, there is no keyword here. Well, there is, but there isn't.
All but.
So C is not the correct answer. All right, I mean, C is the correct answer, sorry, but out-of-state condominiums must register. So out-of-state condominiums must register with the New Jersey Subdivided Land Sales. All right, so all but which of the following need to register? Okay, so the C does need to register because it has a homeowners association. And then the answer to that also is that out-of-state properties, condominiums out of state must also register in New Jersey with the Real Estate Commission or Subdivided Land Sales. Okay, the federal yes.
So what was the answer then?
C, condominiums. Everybody was correct. Condominiums.
Okay.
Right, because it's got a homeowners association. Okay. Okay, so number 15, the Federal Home Loan Mortgage Corporation primarily purchases which loan types? FHA, owner finance notes, VA, or conventional?
It's either A or VA.
Kian and Will have the right answer. It's D, conventional, because Freddie Mac buys conventional loans. And that's what this is, Freddie Mac. Okay, so conventional is the correct answer. 16, Sally works for ABC Bank. Her job duties are to gather documents, review application for accuracy, package the loan, and take each file from pre-approval to closing. What is most likely her job title? Good job, Keon. You have 2 good answers, 3 good answers. And the answer is processor. Ding, 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 ding. Okay, number 17. Which of the following does not loan money directly to borrowers? Insurance company, mortgage broker, cooperative bank, or private lender? Anybody else? All right, A is the incorrect answer. Good job, Jennifer. Good job, Susan. Yeah, Susan, I think it was. All right, so the answer is B, mortgage broker, because mortgage brokers are the middleman. There you go, broker made me think. So broker is the middle person that is shopping the loan to other lenders. But you could get a loan from an insurance company, a private lender, or a cooperative bank. Okay, number 18. All right. Jay decides that he's ready to move out of his parents' home and purchase his own home. He has a roommate who will be moving in, so he would like at least a 3-bedroom house. What should his first step be? A, get pre-qualified by submitting a mortgage application. B, purchase new furniture. C, pick out the house. Or D, purchase a new car to go with the new house. And the A's have it. Get pre-qualified by a mortgage application. Ding, 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 ding. All right. Okay, so this is not math. So Mike and Kathy have $30,000 or 10% down to purchase their first home. Their loan officer pre-qualifies them for several different types of loans. They decide to go with the following scenario. The purchase price is $300,000 with a loan amount of $300,000 and the funding fee of $64.50. What kind of a loan is this? Conventional, FHA, VA, or negative amortization? Keon, you got it. Okay, B is the wrong, A is wrong. Good answer, Leonard. All right, so I will reread the question. Mike and Kathy have $30,000 down or 10% to buy. Their loan officer pre-qualifies them for several different types of loans. They decide to go with the following scenario. Purchase price, $300,000. Loan amount, $300,000. Funding fee, $64.50. What kind of a loan is this? Okay, 0 down payment, ding, ding, ding. Funding fee, ding, ding, ding. C is the correct answer. VA is the correct answer. Okay. All right, next. A lender offers you a very low interest of 2.75% in exchange for part of your equity. What kind of a mortgage is this? A balloon, a shared equity, wraparound mortgage, or equity loan? All right, so you Okay, good. So at least I have one who's, okay, 2 good answers. All right, so the D's are incorrect. I'll start with that. So a lender offers you a very low interest rate, keyword low interest rate of 2.75 in exchange for part of your equity. And now I have some right answers. The answer is shared equity, right? So the bank is going to, I'm sorry?
He's sharing the equity with you, so it's shared.
It's a shared equity mortgage, and usually it's a big development. So when it gets sold off, the bank is going to share in the profits as well. All right, number 21. Sellers Keith and Rita execute a standard purchase and sale agreement November 1. The contract also states that by November 15th, their agent should receive a mortgage commitment letter. November 14th, the buyer's agent sends over a letter that the buyer has been unable to secure financing. What should they expect? Their earnest money deposit back, to withdraw from the transaction, both A and B, or A only? Okay, the cats have it. Meow, that is the correct answer. Both A and B. So the contract was written.
Gloria, like, isn't this dependent on, A and B makes sense, but isn't this dependent on the contract? Like, because some contract might say if you fail to do it, for example, you don't get your deposit back or something, or no?
No.
You know, okay.
The contract is written with a financing contingency.
I see.
How the contract is written, you're saying you're going to get a mortgage. If you can't get a mortgage, you can't go forward with the deal. All right, so the answer is both A and B. They should be able to back out of it and get their deposit monies back. Okay, number 22. And again, you can't read into the question. We're not, you're probably asking me for real life. Again, that's the same thing. It's still going to happen. If they can't get them, again, understand, they wrote it on the 1st and the 15th. That's a 15 days only. If it was 30 days or something like that, that would be a different story.
Yeah, contract review.
Right, so, all right, number 22. Okay, House and Home Realty leased a 2-family residence for $1,500 a month for each unit. The tenant 1 wrote a check to cover the first month's rent and deposit, and tenant 2 paid by money order. Which is the best representation of what the brokerage must do? A, make and keep a copy of all the funds collected from the tenant, each tenant. B, nothing as long as the broker received the money that is sufficient. C, only keep the money or only copy the money order because a check is a legal record. Or D, tell the tenant to pay the owner directly. All right, I got the apples are correct. Make and keep a copy of all funds collected from each tenant. That is the correct answer. All right. Kimberly finds, number 23, Kimberly finds the home of her dreams, a cozy bungalow built in 1932. Her agent suspects that the home may have lead-based paint, so Kimberly has how many days to test for lead-based paint? 5 days, 3 days, 7 days, or 10 days? Okay, I'm having a combination of 2 answers, and C is the incorrect answer. All right, so the correct answer is D, 10 days. They have the opportunity to do an inspection it within 10 days. Okay, the governor appoints 8 members of the Commission of Registration for Real Estate Brokers and Salespeople. How many members are not licensed agents and meant to represent the public? 5, 0, 2, or 3? Okay. All right. So I've got 4 good answers. So the answer is 2. So let's go down the list of how many members are there and what are they. So we know that there's 8 members. So how many of them are New Jersey brokers? Okay. And then therefore 2 are from the public, and the 1 is what?
From the governor?
Yep, ding, 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 ding. Okay, they're all appointed by the governor. Good, ding, 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 ding. Can they be fired by the governor?
Yes, all of them.
Yes.
Ding, 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 ding. And how long is the term?
3 years.
Ding, 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 ding. Good job. Okay. So an appraisal is done on a unique property that sits on 42.5 acres. The approach that the appraiser will more likely use is assumption, cost, income, or market data. Good job, Ken. Okay, good job, Jennifer. Woo-hoo-hoo. All right, nobody else? All right, so the correct answer is cost. The cost approach is used when the appraiser has difficulty finding comps because this is an unusual piece of property. Okay, 26. Jill secures a 15-year fixed conventional home loan. This loan was more than likely purchased by which investor? Fannie Mae, the insurance, and Orb or Ginnie Mae? Good job, everybody. Fannie Mae is the correct answer. Okay. All right. Again, this is not math. A homeowner has an existing mortgage balance of $120,000 with a mortgage payment of $1,375. He puts an ad in the newspaper to sell his owner financing, where he will offer the buyer a new note based on a sales price of $258,000 at 5%. The buyer decides to use this financing to purchase the home. So based on the information that is given, what kind of a mortgage is this? All right, so I'm seeing a lot of apples here, and that is the correct answer. It's a wraparound mortgage. So the new mortgage will include the remaining balance on the existing first mortgage. Okay, so they will include it. So they're wrapping it around that. Okay, or it's also known as a donut mortgage. But that's slang. That's not the real word. When determining whether a buyer is a good credit risk, the lender needs to evaluate what? The borrower's credit, the borrower's ability to pay and the homeowner's age, or ability to pay, property, borrower's 401k, or borrower's credit, future expected value of the property, job stability, or property, ability to pay, and credit. All right, so most everybody agrees that A and B is incorrect. So we're down to C and D. Okay, so in this case, all right, we're getting a little bit more dogs. So woof, woof, D is the answer. All right, the lender must do an appraisal, ensure the borrower has means to repay the mortgage and meet the lender's credit score. All right, whatever their minimum credit score is. Okay, when number 29, when a buyer chooses to pay discount points, her goal is to receive what? So A, cash back at closing, B, a lower interest rate, C, principal reduction, or D, none of this. Oh, we got great answers here. The answer is B, a lower interest rate. All right, good job, everybody. Good job. All right, 30. Kevin's sister decides she wants to purchase a home and needs to get pre-qualified. Kevin's sister's best friend, James, is a loan officer at the bank and tells him once the loan closes, he will give him a referral fee. Which statement is true? As long as James gives Kim the HUD information booklet within 3 days, he can pay a referral fee. James is protected under RESPA. James must disclose the referral amount on the good faith estimate, and fees and kickbacks to individuals who do not provide a loan is prohibited. Good job. If everybody's answering D, that is the correct answer. Fees and kickbacks to individuals who do not provide a loan is prohibited. All right, here we are. Members of the Real Estate Commission serve a term of how many years? 3, 2, 7, or 10? Good job. A is the correct answer. 3 years. Ding, 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 ding. Okay. The purpose of which of the following laws is to prohibit discrimination on the basis of race only in the sale of real property? So is it the New Jersey statutes 10(2)5-4, B, the New Jersey Consumer Fraud Act, C, the Federal Civil Rights Act of 1866, or D, the Federal Fair Housing Act of 1868? It looks like I got the right answers here. The answer is Federal Civil Rights Act of 1866. Ding, 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 ding. Okay. Another name for HUD-1, well, you guys may not know this one. So well, if somebody wants to take a guess, it's either a good faith estimate, uniform settlement statement, truth in lending document, or housing uniform document. All right, so the correct answer, a HUD-1, is the same thing as a CD. So what is a CD?
Closing disclosure?
Yep, ding, 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 ding. And so therefore, in this case, based on that, it's the uniform settlement statement, right? So settlement means we're closing, just as an FYI. Okay, good, thank you very much. All right, a homeowner attempts a refinance on his home only to find out that the home has 2 liens from the previous owner that were never paid off. So who should he contact? A, the title insurance company, B, the escrow office, C, the loan officer, or D, the real estate attorney? The A's have it. Ding, 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 ding. The title insurance company is the correct answer. Ding, 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 ding. Okay, we're doing good. All right, 35. All listing types below allow the seller the right to sell their property on their own without paying a commission, except, all right, so A, exclusive agency, B, open listing, C, exclusive right to sell, D, none of the above. And the cats have it, meow, exclusive right to sell, ding, ding, ding. We get paid no matter who brings the buyer. Okay, 36. Kurt receives a letter that an expressway is being built where his property sits. The state offers to purchase his home. What right are they, the state, exerting? Are they exerting escheatment, foreclosure, adverse possession, or eminent domain? And woof, woof, the dogs have it. The eminent domain, ding, 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 is the correct answer. Okay, number 37. A family leases a home with a pool. The contract states that the owner will pay property taxes and insurance, but the tenant must pay the pool and the yard expenses. So this is known as what kind of a lease? A percentage lease, a gross lease, a net lease, or a month-to-month lease? Good job, everybody. C is the correct answer. Net lease is the correct answer. Okay, 38. Mr. Green has purchased a new energy efficient windows, put weather stripping around the doors, and replaced the old wall heater with the new central air and heating system. Mr. Green has done what to his home? Weatherized, energized, overhauled, or redlined? All right, energized is the correct answer. All right, I think these questions are way too simple. All right, so based on that, we're going to go to Gloria's famous, do you know the numbers? Okay, it's not, it's, I don't know if it's online. Do I have it online here? Oh, I probably have it as a Google. All right, but you're gonna answer the questions. Okay, so number of business days that you can hold a trust account check. Okay, I gave you the answer, 5 business day, so it's 5 business days. Okay, familial status means living in the household, children living in the household under what age? Under the age of 18, ding, 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 ding. Number of hours a broker candidate must attend school for in order to qualify for the broker's test. Ding, 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 150 is correct. The New Jersey real estate license law is known as Title what, Chapter what? Jennifer, ding, 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 ding. Oh, you're missing one. Sorry, take it back. That's a half a ding.
Gloria, are you displaying this? I don't see what you're reading.
I'm not, it's not on there. It's not on the screen. So the half a ding is Title 45, but now I need a different chapter number. There we go, Ange. Good job. So the answer is the New Jersey real estate license law is known as Title 45, Chapter 15. Okay. The cost to renew your salesperson's license is? Ding, 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 ding. $100 is correct. Okay, a salesperson must be paid by the broker within how many days? Okay, 10 is not a good answer. 10 business days, ding, 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 ding. 10 business days is the correct answer, or as soon as the check closes. All right. The length of time a listing salesperson has to send the seller written contract offers. Woo, good job, everybody. Ding, 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 ding. 24 hours is the correct answer. All right. Any cash deposit of what must be reported by the broker to the IRS? 10,000, ding, 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 ding. Okay, that's the correct answer. Minimum age a person can qualify for a real estate license. 18, ding, 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 ding. All right, the cost to activate a new salesperson's license is how much? All right, so far I don't have the correct answer, unless I'm wrong, but I don't think I'm wrong. I don't think the numbers change. Thank you, Jennifer. That's the correct answer. 160. I don't know where people are getting 170 or 75. So 160 is the correct answer. Ding, 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 ding. Okay. How long must a broker keep transactions on file? Good. 6 years. Ding, 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 ding. Okay. For the purpose of a real estate test, all months have how many days? Ding, 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 ding. 30 days is correct, and 360 for the year. If a building was constructed before what year must we give a lead-based paint form? Nope. Yes, yes, yes. Nope. So 1978 is the correct date. Any house or property built prior to 1978 will need to have a lead-based paint disclosure form. Adverse possession in New Jersey is how many years? Nope. Nope. 30 is the correct answer. Ding, 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 ding. In the book, it says 20. It's incorrect. Change it to 30 years. Okay. If a salesperson leaves the broker, what must the broker must give a written account to the salesperson of the monies that are eventually due within how many days of the salesperson's departure?
Can you repeat that, please?
Yep. If a salesperson leaves a broker, the broker must give a written account to the salesperson of monies due after the salesperson's departure within how many days? Nope. Anch is correct. Anybody else? All right, so the answer is 30 days. Okay. Under the Truth in Lending Act, second mortgages, home equity loans, the buyer has a rescission period of how many days? Second mortgages and home equity loans, the buyer has how many days? Ding, 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 Jennifer, good job. 3 business days. All right. Tenancy at will may be terminated at any time by the party upon how many days or months notice? Okay, so 90 days is the correct answer, right? Or 3 months, right? Okay, so 90 days or 3 months. Okay, the period of time a broker must keep rejected offers or expired listings. Good job, Selena. 6 months. That's the correct answer. Ding, 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 ding. So rejected offers, they didn't go into a transaction, or expired listings, there was no transaction. The broker needs to just keep them for 6 months. All right. The right of redemption for a seller to pay their tax lien and get the property back after tax sale is how many years? Good job. Ding, 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 ding. 2 years is the correct answer. Ding, ding, ding. If the real estate licensee has been convicted of forgery or burglary, within how many years the commission will not issue a license? No, and no, and no. So if a real estate licensee has been convicted of forgery within the last 5 years, the real estate commission will not issue a license. Good job, Selena. All right, attorney review is how many days?
10 days.
Nope, 3 business days. Ding, 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 ding. 3 is not good. Business days, I have to have that. Ding, 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 ding. Good job. 3 business days. All right. The amount of notice that a real estate commission must give the broker when checking files. The amount of notice that the real estate commission must give checking a broker's file. Does the real estate commission have to notify the buyer if they're coming, the broker if they're coming over? Oh, thank you, Will. None, 0, zip, nada. Okay. The real estate licensee, after completing successfully the course exam and the state exam, has how long to activate their license? Ding, 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 ding. Okay. Capital gains for a single person is considered how much? Okay, exemptions, okay. Capital gains exclusion for married is how much? 500, ding, ding, ding. And it has to be, does it have to be a primary residence?
No.
Yes, out of how many years? 2. 2 out of how many? 2 out of 5. Ding, 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 ding. So capital gains exclusion is to be a primary residence 2 out of 5 years, and they can exclude $250,000 as a single person or $500,000 as married people. The length of time that a salesperson has to notify the real estate commission to apply for a temporary broker's license after the death of a broker is how many days? 30 days. Ding, 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 ding. Good job, everybody. The Land Sales Disclosure Act, the right of rescission is how many days? Good job, Will. 7 days, ding, 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 ding. So that in this case is new construction. They have the right to cancel the contract within 7 days. All right. Okay, so this is a trick question. A tenant with a 1-year lease has how many days notice if he intends to vacate on the date of the lease? Okay, I said it was a trick question. Only one person got it. I will repeat it again. A tenant with a 1-year lease. Oh, we're getting it. We're getting 3 good answers, 4, 5. Okay, so the answer is 0 days notice because it's a 1-year lease, which has an ending date, and they intend to vacate on that date. All right, so what kind of a lease is that also known as? Period of years. Yep, for years is the correct answer. All right, so again, if it's a lease for a period of years, then it means there is an end date and they intend to vacate on that end date. Therefore, there are 0 days to be notified. All right, because they intend to leave on that date. Okay. The maximum amount of dollars paid out to an aggrieved person from the guarantee fund is how many dollars? All right, somebody's been upping the dollars, so that's not correct. Be nice, but it's not. So 20,000, ding, 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 ding. You're on the right track. Okay, good. Now, a tenant with a month-to-month lease must give how many days notice? Good job, 30 days. Ding, 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 ding. That is the great answer. Okay, the Federal Fair Housing Act was passed when? Year, just the year. Ding, 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 ding. 1968 is the correct answer. It is also known as Title what? Title 8. Ding, 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 ding. Okay. The cost of a real estate broker's license is how much? $270. Good. All right. And how many hours must you salespeople take to take the state exam? 75 hours. Ding, 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 ding. Do we have continuing education? Yes, ding, ding, ding. 4 hours is incorrect, by the way. It's 75 hours. All right, so yes, 12 hours. Okay. By what date must we have our continuing education done? April 30th, ding, ding, ding. All right, so now the best answer that I got is from Christine, April 30th of the renewing year. That is the best answer. April 30th is correct. However, we're talking about the renewing year, not any other year. Okay, so that is the best answer, but you guys were on the right track. All right, and if we don't get our continuing education by April 30th of the renewing year, are we going to have a processing fee? $200. Ding, 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 ding. Okay. What was the other question I wanted to ask? All right. Okay. So how are you all feeling now?
This part is kind of easy, but the other one wasn't.
It's been a long day.
It has been a long day. All right. So, all right. So let's go to, hold on. I'm not going to make life easy 100%, but I will make it somewhat easy. Did anybody answer this? No, I don't think I can mark it. Oh, I can mark it. Okay. So real property or personal property, fixture or trade fixture. So sidewalks and sewers in a subdivision is?
Trade fixture?
No.
Real.
Real.
Real. Good. Thank you. All right. Bushes surrounding a residence, personal fixture or trade fixture? Fixture. Okay. All right. Wheat or corn crops on a farm?
Personal.
Personal. Ding, 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 ding. Okay. Kitchen sink installed in a home?
Fixture.
Fixture. Ding, 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 ding. Booths in a restaurant installed by the tenant?
Trade fixture.
Trade fixture. Ding, 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 ding. Curtains installed by a tenant?
Personal.
Fixture.
Personal. Ding, 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 ding. All right. Pumps installed by a gas station tenant?
Trade fixture.
Ding, ding, ding. Okay. A water well pump installed by the landowner?
Real.
Real.
Ding, 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 ding. Crystal chandelier hanging in the dining room?
Personal.
Personal. 80-gallon water heater with fiberglass insulating jacket?
Real.
Real.
Real. All right. Real, or it could be fixture also, right? Because it's attached to the house, right? All right. So we did good on that one. Okay. So let's empty that one out. Where's the other one? Ownership. Which one is this one? Oh, yeah. Let's go to this one. All right. A condo. Corporate ownership, undivided interest in common elements, occupancy and use for limited periods, proprietary lease, or fee simple ownership.
Fee simple ownership.
Okay. Anything else? I can't mark it, but anything else?
Proprietary lease.
Nope.
Corporate ownership.
Corporate ownership? Nope. Could be, but
Undivided interest in common elements.
ding, 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 ding. So condo, undivided interest in common elements, and fee simple ownership. All right, let's go to co-op. All right, corporate ownership, undivided interest in common elements, occupancy used for limited periods, proprietary lease, or fee simple ownership. Corporate ownership. Okay, what else?
The common elements.
Okay, what else?
Well, no, I don't know. Could it be a fee simple ownership too?
No, we're talking about a cooperative. So undivided interest in common elements, yes, but the answer here is proprietary, right? The co-op buying a share, so it's personal. Would that be considered personal property or real estate?
Personal?
No, co-op is not a personal property, is it? No.
Yes, a co-op is personal property because you are buying a share, you're buying stock in the building, and you have to have a proprietary lease. So it's personal property. It is not real estate. All right. And then timeshare, what do we have for that? Well, Will said limited periods. That's correct. What else?
Is that a corporate ownership too?
No. Timeshare, no.
Okay.
Be simple ownership.
Fee simple ownership, yes. Timeshares, yes. So timeshares is fee simple, occupancy, limited periods, and undivided interest in common elements. Okay, those are the main aspects of that. All right. Oh, which one is this one? What do I have here? Oh, nothing. All right, well, that's the one I don't have.
Awesome.
All right, what else do we have here? Oh yeah, let's go over here. Glossary.
Ay, ay, ay.
All right, we're gonna get this, okay? What does divulge mean? Does it mean clandestine, hide, print, or disclose? Good. All right. Fiduciary, indenture, trust, warranty, or agency. All right, I like that one too. Trust. Okay, one who has the right to sign the name of his principal to legal document is option E, special agent, attorney in fact, or attorney at law. Attorney
at law.
Ding, 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 ding. No, in fact.
In fact.
Ownership concept, which embraces the rights of possession, use, disposition, and enjoyment, is called what? B, bundle of legal rights. Ding, 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 ding. Littoral property is trash on the streets, property that has precise measurements, borders an ocean, or land beneath a stream. Borders an ocean, ding, 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 littoral property. The residue of an estate left to a grantor or a leaseor after termination of a previous estate is that reversion, inversion, restitution, or surrender. Reversion, ding, 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 ding. The word consummate most nearly means tender, soup, shut, or complete. Complete is the correct answer. Ding, 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 ding. Agent most nearly means one who represents another, one who holds realty at sufferance, one who is the source of another's authority, or one in whom complete power. All right, A is the correct answer. One who represents another. Ding, 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 ding. A shareholder in a cooperative apartment has what? Fee simple interest, irrevocable right of possession, leasehold interest, or a conditional life estate. C is the correct answer, leasehold interest. Chattel is another name for a wife's equity in the husband's estate, tangible personal property, survivorship rights, improvement to property. All right, B, tangible, is the correct answer. Ding, 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 ding. A person to whom a devise had been made would receive what? Property under a court order, mixed property in a will, real or personal property in a will, or died intestate. C is the correct answer. Ding, 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 ding. Waiver could mean all of the following except, okay, restitution, renunciation, abandonment, or surrender. Could mean all of it except. All right, so we have, what do we have here? Oh, we've got all three. All right, waiver, mean all of the following, except. All right, I'm going with C, abandonment. All right, you can't waiver an abandonment. The word revoked most nearly means what? Repealed, recalled, rejected, repaired, or reviewed. A is the correct answer, repealed or recalled. Reversion of property to the state is called what? Escheat, descent, remainder, or dedication. Oh, look at you guys. You guys are getting good at this vocabulary. Biennial means twice a day, 2 times each 2 years, every 2 years, or semi-annual. Good choices, Anj. The second choice is correct. C is correct. All right, biennial is every 2 years. The rights to the water of a person owning land containing or bordering upon a stream are called bridge rights, riparian rights, eminent domain, or reservation. B, riparian rights is the correct answer. To convey most nearly means what? To buy, to warrant, to obligate, or to transfer. Ding, 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 ding. Transfer is the correct answer. And dual agency occurs when a broker maintains 2 offices, a real estate broker employs 2 agents, a broker represents 2 clients in the same transaction, a broker has dual customers in the same transaction. And C is the correct answer. Ding, 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 ding. Let's see how we all did. Oh, well, all right. So I'll put in my email. We all did good anyway, I can tell you that. Glory be, oops, can't spell it. 2008 @gmail.com. And there we go. And why is it not going? Because I have no idea. All right, there it is, submit. Okay, forget it. But
you have to put your name there too.
All right.
I did that the other day.
I'm killing myself here. All right, so there we go. View score. Let's see what we did. Look at that, 160 out of 180. All right, so where was our mistake? All right, it's a special agent. Okay, one who has the right to sign the name of his principal to legal documents. That's incorrect. That's incorrect. I'll have to fix that. All right, what was the other one? This one here, waiver. Oh, restitution. Oh, okay. Restitution means to make good. The commission may impose restitution of monies. All right, look at that. I learned something new. All right, so restitution. So waiver does not include restitution. All right. And that's it. So good job, everybody. So I know your brains are dead. So I have no clue what I'm talking about, but it sure looks like 10 o'clock. But just understand that 10 o'clock, okay, means that you better take advantage and do some studying and reading. All right, let's understand that. So no word for today, no word for tomorrow, and we'll continue with some more testing tomorrow. All right?
Have a good night, Gloria.
All right, so y'all have a good night.
Gloria, I have a question.
Okay.
Have a good night, everybody.